All right. So, while the funding will help us make an impact immediately on the border, it will only serve to mitigate the crisis. It's not going to address the fundamental drivers that are contributing to it. It is our hope that this bipartisan effort in the Senate, based on a shared set of facts on what's happening on the border, could be a catalyst, not only for our funding needs, but also in a targeted and focused manner for addressing the weaknesses in our legal framework that, along with our booming economy, have created the pull factors that are fueling this crisis. As the President has made clear, Congress has the power to change the dynamic of migration flows in the region swiftly, with several key changes to our immigration laws. We are asking for 3 straightforward fixes to our laws that will help restore integrity to the immigration system at the border and remove the incentives for families and children to cross our border illegally. First, we need to address the pull factors for family units. Currently, due to a single federal district court order, we cannot obtain effective immigration enforcement results for the families arriving at our border. Instead, they cannot be held longer than 21 days and as a result do not receive rulings from immigration courts for years. Once a final order is issued from a judge, ICE officers have to go into communities to enforce it and repatriate the family. A better approach is needed and is available. Simply put, we want to be able to address immigration claims as families are encountered at the border by holding families together in appropriate settings during a fair and expeditious immigration process and ensuring that a judge or asylum officer's decision can be effectively implemented. Second, to prevent unaccompanied children from being placed in the hands of criminal smuggling organizations to make a dangerous journey north, the administration has proposed that those seeking refugee or asylum protections should be able to do so within their home country or in a neighboring country. If they meet the standard, they could be protected there or considered for placement in the United States. If they do not have valid protection claims or avoid this safe and orderly process to come to the U.S. border, we are asking for an amendment to our laws to allow us to repatriate them in coordination with the host government. And third, the current asylum standards are misaligned, with a significant difference between the number of migrants who meet the initial credible fear standard, over 80%, but do not have a valid asylum claim at the end of court proceedings, only about 10 to 20%. This allows for migrants arriving at the border to stay for years in the United States, even if they have a very weak claim. These changes were recommended by the Homeland Security Advisory Council Task Force, a bipartisan panel led by experts from across the political spectrum. The legislation proposed by Senate Judiciary Chairman Graham would address these vulnerabilities and end the crisis, and we stand ready to discuss these sensible solutions or others with any willing members of Congress. The time to address the fundamental drivers of this crisis is now.